going to be talking about litigation and other forms of advocacy. So this subsection of the rules makes up 10 to 16% of your total MPRE examination. The first rule that I would like to direct your attention to is candor to the tribunal. So this rule has multiple parts, so we're going to pull it apart piece by piece and also talk about some examples. So let's get started. The rule says that a lawyer shall not knowingly make a false statement of fact or law to a tribunal, or fail to correct a false statement of material fact or law previously made to the tribunal by the lawyer. So let's stop there. This is pretty loaded, but what this says at its most basic level is that you should not lie about the facts of your case or about the law as it relates to your case. And it goes on to say that if you find that you have made misrepresentations about the facts of your case or about the law, you need to take steps to correct it. So your example says, a lawyer cannot argue that a case is controlling when she knows that the highest tribunal in the state has reversed it. Second example, on a traffic ticket case, the judge says, since this is your client's first speeding ticket in over 10 years, we'll drop the ticket. If the lawyer knows that this statement is false, the lawyer would not have to correct the judge unless the lawyer or his client made this mistake. So the key is, you, as the lawyer, as the advocate, cannot be the one that's making misrepresentations about the facts or the law. And if you find that you have, maybe your client lied to you and you represented something to the court, and then you later came to find out that it was in fact not true, you need to correct that representation. So the second part of the rule says, a lawyer shall not knowingly fail to disclose to the tribunal legal authority in the controlling jurisdiction known to the lawyer to be directly adverse to the position of the client and not disclosed by opposing counsel. So first things first, this rule is annoying. It's basically telling you that you need to do opposing counsel's job when opposing counsel's not doing it. So keep that in mind. And number two, the other thing to keep in mind is the language. Here the rule uses the words controlling jurisdiction. So I want you to pay special attention to those jurisdictional facts that are provided to you in your fact patterns, because those could be there for a reason as it relates to this rule. And this is because you as a lawyer do not have to disclose to the court authority that's not from your controlling jurisdiction. The only thing that matters is that you are disclosing the information from your jurisdiction, the controlling jurisdiction. So if you're in a situation where opposing counsel hasn't done their due diligence, they haven't performed the appropriate legal research, and you know there's case law on point that hurts your client that they haven't disclosed from your jurisdiction, you need to bring that information to the court's attention. So turning to your example on this point, found in your outline, it says a lawyer is arguing a motion in a lower court in State A. There are two cases on point with very similar facts, however not favorable to the lawyer. One is from a lower court in State A, and the other is from the highest court in State A. Because they come from the controlling, there's also a case on point in State B. The lawyer has to disclose both of the cases from State A because they're from her controlling jurisdiction. The lawyer does not have to disclose the case from State B because it's not from her controlling jurisdiction. So those are the types of jurisdictional facts that I would be on the lookout for on your exam or on your practice exams. So we're still not done with this candor to the tribunal rule. It has another part. So it says a lawyer shall not knowingly offer evidence that they know to be false. If a lawyer, the lawyer's client, or a witness called by the lawyer has offered material evidence and the lawyer comes to know of its falsity, the lawyer shall take reasonable remedial measures, including disclosure to the tribunal. So I want to stop there. This is, again, a very loaded rule, as the previous portions have been as well. I want to first explain that this rule pertains to you as the lawyer and the words you speak and the arguments you make. But it doesn't stop there. It extends to those people you put on the stand. So maybe you call your client to the stand. Maybe you call a key witness that your client's identified to the stand. So you need to make sure that because you're offering their testimony as evidence, that they too aren't lying. If you know they're lying and you know what they're representing is false, you have an obligation under these rules to take reasonable remedial measures. So how do you fix this? What do you do as a lawyer if you come to find out if testimony that maybe you've offered is in fact false? So let's break down the steps that you should take. The first step is to talk to your client in confidence. Advise them about your ethical obligations under these rules and the fact that you can't offer false evidence. Seek your client's cooperation with respect to maybe withdrawing from the action, assuming that would fix the problem, or correcting the false statement or the false evidence. Ideally, they would comply. You would kind of level with them and tell them what your obligations are, and they would let you do what you need to do. But if that fails, your obligation doesn't end there. You still have to take steps to remedy this representation of false evidence. So if withdrawal from the representation is not allowed, or if it does not undo the effect of the false evidence, then you as the lawyer must make disclosure of this false evidence to the tribunal as is reasonably necessary to remedy this situation, even if doing so requires the lawyer to reveal information that's otherwise protected by the duty of confidentiality. And then basically it's in the court's hands to decide what they're going to do in light of that evidence you've given them. So to stop there, ideally, again, your client will let you fix the mistake, but if not, you have to take the next step and usually reveal the information to the court. But please be sure that you're only revealing as much information as is necessary to remedy the situation. You're not going to disclose everything and anything that's not relevant. You're only going to disclose as whatever is necessary. And the rules here tell us that our duty here continues to the end of the proceedings, and they clarify what that means specifically. So this means that a final judgment has been affirmed on appeal or the time for appeal has expired. So in this case, it is final because there's no ability to appeal thereafter. The other thing I want to point out that I haven't mentioned yet is that this rule utilizes the word knows. So that means there's a knowledge requirement here. So if you have a situation where the lawyer merely suspects that someone is lying or merely thinks someone might be offering false evidence, that doesn't trigger this rule. Now, a lawyer can't turn a cheek and claim that they don't know something when they do. So there is a difference. But if a lawyer just merely suspects that maybe someone is testifying falsely or might testify falsely, it doesn't trigger this rule. So let's say, for instance, a man is being represented by a lawyer, and let's say it's a personal injury action. And the lawyer gets to know his client a little bit, and trial's approaching. And the lawyer really gets this bad feeling that the client might lie on the stand. Does this rule preclude the lawyer from putting the client on the stand? The answer is no, because the lawyer doesn't know that the client is going to testify falsely. I want to give you another example not in your outline. Let's say a man hires a lawyer to represent him in an action against the government because the man is essentially alleging that his land was taken by virtue of a regulation that was passed, and he's entitled to just compensation for that regulatory taking. And the lawyer is representing this man, and the lawyer puts the man on the witness stand to testify, and the man testifies that he paid $100,000 for the land in question. Later, the lawyer finds out that was a lie. The man only paid $50,000 for the land. So the lawyer tells the man, we have to correct this false statement. And the client, the man, refuses. So in that instance, the lawyer would have to take the next step and reveal to the court the fact that the man lied and that the land was only $50,000 and not $100,000. And the court would decide what to do from there. So turning to the next portion of this rule, and it's slightly different than what we've discussed so far. So this next portion of the rule talks about what do you do if you know your client will testify falsely. So remember, we just talked about a situation where you put someone on the stand and they lied. This next portion of the rule is talking about what do you do if you haven't yet offered the evidence, but you know someone's going to lie. So we're talking about two different moments in time. So turning to this specific instance, when you haven't yet offered the evidence, but you know someone wants to lie, what do you do? And the answer is it depends on the type of case you have. So let's first talk about how you handle this with regards to a civil case. So in a civil case, if you know that your client intends to testify falsely, or if they want you as the lawyer to introduce false evidence, the lawyer should first try to persuade the client that they shouldn't testify falsely or that the evidence in question should not be offered. And if for whatever reason this persuasion is ineffective and the lawyer still decides they want to represent this client, the lawyer should just refuse to offer the testimony or refuse to offer the false evidence in question. So to clarify here, there is no right for a civil client to testify. It might really make your client mad if you refuse to offer their testimony, but they have no sort of constitutional right, for instance, to take the stand. Now, keep in mind, if only a portion of your client's testimony is false, or if your client just wants to testify falsely as it relates to a certain aspect, maybe you could put your client on the stand and not ask about those types of issues or not get into the area in which your client intends to falsify their testimony. But generally speaking, know that you have a right as a lawyer in a civil case to not offer that evidence. Just don't put that person on the stand if that's the best route. Now, in a criminal case, your approach is different, and this is because your client or criminal defendant specifically does have constitutional protections about their ability to defend themselves and to testify on their own behalf. So if you're dealing with a criminal, say, defendant that you're representing and they tell you they want to testify falsely, what do you do in this instance? Well, the first step is similar to the first step we outlined above. You still want to try to level with your client. You want to try to persuade them to not do what they claim they want to do. Explain to them maybe why you can't let them testify falsely. Explain to them what will happen if they testify falsely, because that you have these ethical rules that do not allow you to offer false evidence. The rules tell us that you should also consider withdraw if that will solve the problems, but please note that it usually doesn't. And then the third step here, or the final requirement, is that you need to reveal the situation to the judge and let the judge decide what to do in this circumstance. So again, the key difference between that civil and criminal case is that a criminal defendant or client has a right to testify where your civil client doesn't. The final rule in this section that I would like to cover is all the way kind of at the end of this section, and it's all about lawyers acting as a witness. So let's talk about the general rule first. Lawyers should generally not act as a witness absent an exception. So a lawyer shall not act as an advocate in trial in which they're likely to be a necessary witness. And I just want to stop there. I think this rule makes some common sense. It would be very strange and awkward if you had a lawyer who was questioning witnesses and crossing witnesses and introducing evidence to the jury, and then he or she goes and gets in the witness box. It would just be very strange. And that's why this general rule exists. We don't want someone acting as an advocate in trial and then later testifying as well. And it just doesn't make a lot of sense. And it also, I think, confuses things for the trier of fact. So the general rule is they shall not do that. Now let's turn to the exceptions. The first exception says that you can be an advocate at trial and a witness if you're going to be testifying to an uncontested issue. The second exception is if the testimony relates to the nature and the value of your legal services that have been rendered in the case. Or 3, if disqualification of the lawyer would pose substantial hardship upon your client. So if you don't have one of these exceptions that are applicable, the general rule is you as a lawyer shall not be the advocate for someone or for a case and simultaneously be a witness. The other thing I want to stress is the word necessary. Sometimes you'll get questions that really are testing the plain language of the rule. So if the lawyer is very clearly a necessary witness in the case, they shouldn't be the lawyer for the matter then. Because if they're needed to be a key witness or a necessary witness, they should be the witness and not the lawyer, because they can't do both. The only exceptions are if they're going to testify to something that's uncontested or testify to the nature and the value of their services, or if their disqualification would pose some sort of substantial hardship upon the client. So the next part of this rule says that a lawyer can act as an advocate in a trial in which another lawyer in their law firm is likely to be called as a witness unless precluded from doing so by the conflict of interest rules. So this is a situation where maybe you work at a big firm and one of your associates is representing a client that maybe you've previously worked for, or you have information regarding the case. And your associate will be their advocate at trial, but you're a witness at trial. Can you be called to the witness stand to be a witness while one of your coworkers is the lawyer for the case? And the answer is yes. As long as that in your testimony does not amount to a conflict of interest, that's absolutely fine. Why? Because you're not the witness and the advocate. Someone else at your firm is the advocate and you are the witness. So that wraps up our discussion of this subsection of the rules.